So, yeah, welcome everyone to the EMEA session of the 2026 Young AIPPI Members Summit. My name is Niklas Geig. I'm the chair of the Young AIPPI Members Committee. And before we go into the midst of the session, we're starting with some welcome remarks, and we're very happy to have with us today for that Debbie David, who joins us as Assistant Secretary General of AIPPI. Debbie has been very active in the young member space as well. She's been a founding member and president of this committee, so former chair during her time, and she now made the move to the Secretary General team, where she continues to support us a lot, and we are very happy and appreciative for that. So Debbie, please, the floor is yours.
Thank you, Nicholas, for your very kind words. Good day, everyone, and welcome to the second of our satellite sessions today. And thank you for sharing a little bit about my history. I was really excited to have the opportunity to come back and still support and work with the Young Members Committee. So it's a great joy for me to be back in a different role this time. I just really want to welcome all of you to our satellite session today. And I'm really looking forward to the speakers and the topics ahead. Yesterday and today, and just about an hour or so ago, we had the AI session, as well as the Asia Pacific satellite, and they were all really great topics. And I learned so much from all the previous sessions. And I know I'm going to today and later today at the Americas session as well. On behalf of AIPPI, we just want to warmly welcome you to this event. Thank you for taking your time out. Thank you to our moderator and speakers for this session, Lynn and all the other speakers, for your time, for your efforts, and just making all the preparations for us today, and for supporting the young member community of AIPPI. And for those who are a first time, you may wonder, like, why is that satellite session and what is it for? It's really twofold. One is it's in a time zone that's perhaps more comfortable for you, as well as number two, we also want to feature topics that might be relevant to the region, which is why these satellite sessions are set up throughout the course of today. I really want to encourage all of you as participants to listen, to actively participate, to ask questions, and I know that you will surely enjoy the session ahead. I'm not going to take up too much time, and that's all I really want to say. Just welcome and really looking forward to it. And last but not least, for those of you who will be in the Congress in Hamburg in a couple of months, really looking forward to seeing you there in person. So that's all I have, and Nicholas, I'll hand it back to you.
Hi, thank you so much, Debbie. No, it's a real pleasure to have you with us and to have you lift up our spirits basically in advance of what is now to come, the very interesting bits of the EMEA session. Before we dive into that, maybe just a very big picture overview from my end. So we're now in the middle towards the end of the summit program. We've already had a variety of sessions, yesterday in particular, global session, ideas exchange session on the topic of AI and prompting. An Asia Pacific satellite session, which occurred just before this one. And if you can, please make sure to, after this EMEA session, also tune into, register for, if you haven't yet, the America satellite session, which is scheduled to be held later this day. So who is actually organizing all of this? So we're the Young AIPPI Members Committee. We're here for all of your questions, concerns, ideas, hopes, wishes with regard to young member activities within AIPPI. If you want to get involved in AIPPI and you don't know how to, if you already have some ideas and you want to realize them, if you're working with young members on a national level, or if you want to work on a national level with young members, all of these items are something that we can help you with, because we know how AIPPI works, we know how the young member space works, and we can connect you and facilitate that. So then in either of those cases, please feel free to reach out to us, any of us, anytime. Yeah, these are some of the some of the things that we are hoping to help you with, networking, collaboration, connection in the IP world, in the young member space within AIPPI. And we intend to do so in particular through the events that we are facilitating for you, including the summit, but also, for example, our in-person event, the forum, which is being held next at the AIPPI World Congress in Hamburg. Make sure to register for that one. You will also notice that there are various national AIPPI young member events. These are hosted from national or regional groups. And for example, this year in November, there will be a trilateral between the French, German, and Italian group, which is then being held in Milan, but also hybridly. So you can also attend online if you cannot make it to Milan. Always have an eye open for these kind of events because they are also a great opportunity either to speak on topics that you're passionate about as a young member or to connect with on a peer level group. Finally, looking towards the further future, of course, next year there will also be a lot of events, probably starting with a midterm meeting, and you will definitely find various young members there as well. If you can register, if it's close to you, then make sure to attend that one as well. Right. That brings me to an end, and I'm happy to hand over to our moderator, Lynn Safadi, for the introduction to the topic and the speakers, and we're very much looking forward to a enjoyable and fun session today. Lynn, the floor is yours.
Thank you, Nicholas. I'm just going to share my screen. Okay. Good morning and good afternoon, everybody, depending where you're joining us. I'm going to be the moderator of this session. As Nicholas mentioned, this is going to be the second satellite session for today and for the summit. And we're going to discuss protecting sport events and athlete identity in IP and enforcement in the EMEA region and beyond. This is going to be a condensed session. We have 6 speakers, so please keep your question till the end. We're going to just put them in the question box and we're going to answer them at the end. And the webinar will be also recorded for anybody who wanted to attend and is missing it. Also, we'll have a survey after the webinar and we would very welcome your feedback. So the session will be split into 3 sections. The first is Game Set Protected Sports in EU, Belgian, and French IP law, where Myrtle, Gevers, and Pauline Choupot will discuss. And the second section is sports in the online ecosystem, generative AI challenges and timely enforcement in the EU. EMEA, Varty, and Chiara will gonna present us on this topic. And the third topic we're gonna discuss today is advertising and sports litigation by Zia Chow and Raphael Zingg. Okay, so with our first speaker, Myrtle Gevers, is a Belgian lawyer working as a senior associate at Litigation, Liederkirche, and specializes in IP and emphasis on complex litigation cases. She works with clients across a wide range of industries, including sports, retail, healthcare, and tech and media. Myrtle holds degrees in law and IP ICT from University of Ghent and KU Leuven, and is also a member of several IP networks, including AIPPI, Benelux, and Marks. Her excellence has been recognized in IP Stars and Legal 500. She's going to discuss protecting athlete identity in the EU, Benelux, and Belgium. And our next speaker in this topic is going to be Pauline Choupot, who's a French lawyer and works as an associate in GenAI, where she practices intellectual property law with emphasis on trademark, copyright, patents, design, domain names, and unfair competition. She advises and presents French and international clients in both advisory and litigation matters. Her practice covers the protection and building strategies to secure intangible assets, exploitation, enforcement of intellectual property rights, as well as disputes regarding to infringement, validity, ownership, and unfair commercial practices. And she's going to talk about sports branding and IP in the Olympic Games. And the floor is yours.
Thank you. I will share my screen as well. So now you should be able to see my screen. So good morning, everyone. Today I will talk about something that sits right in the intersection of sports and intellectual identity. And when we talk about identity, a name and an image. And in the EU, Benelux, and Belgian legal landscape, there are two main legal tracks to protect these, being trademark rights, registering your name, image, signature move, like Mbappe as a trademark, and then personality rights, the right to your name and portrait. So in this presentation, I will discuss these rights and as well their limitation based on case law examples, and I will give you the key takeaways. And given our limited time, I will only highlight the most important aspects. So trademarks first. I will walk you through the life cycle of a trademark from registration to invalidation.
And
there are two topics.
To interrupt, we can't see your slides.
You can't see my slides. So now you see it?
That's great.
Yes.
Okay, so now I have to share my screen. That's not what I wanted to do. I'll begin again. Sorry for this hiccup. Share. And now you see it. Yes, perfect. So I was referring to this example of Mbappe. Now you see the trademark. And now we go to the life cycle of trademarks from registration to invalidation. So as I was saying, I will not discuss two topics in the life cycle, but as you can see on the slide, the limitation to the rights and the transfer of rights. And as to the limitation of rights, I just want to refer to the Unibet case that we had here in Belgium, which was a perfect example of the limitation for referential use. And in this case, the Belgian court held that betting websites were allowed to use images for and names of football clubs PSV, Juventus, and football players Zidane and Beckham to promote bets regarding the games, as this was a mere referential use, limiting trademark rights. And in the Maradona case regarding the transfer of trademark rights, the post-mortem transfer of trademark rights to his company was reversed at the request of Maradona's heirs because it was based on documents of Maradona that only allowed a commercial exploitation rights. And as this did not prove a transfer of rights. And as Maradona was deceased at the time of the transfer, the rights remained in the hands of the heirs and the company did not own these rights. With those briefly explained, we can now dive into the rest of the life cycle. And we'll start with the first stage, registration. Can athletes actually register their name as a trademark? And this question does not always have a straightforward answer. as these two cases illustrate. And we will start with the right case, the Messi-Massi case. I presume you all heard of it. So in this decision, the Court of Justice of the European Union confirmed the application of the principle of neutralization. And what is this principle? Well, this principle allows clear conceptual differences between two signs to neutralize visual and phonetic similarities. Because according to the CJEU, only a minimal part of the relevant public would not associate Messi with the football player. And this association to Messi created a clear conceptual difference with Massi, neutralizing the visual and phonetic similarities, and the results, the registration of Messi was allowed. This was not the case in the Max Verstappen case on the left hand. And here, Max Verstappen tried to register Max 1, being Max his name, and 1 his race number. And this application
I think Myrtle just froze, right?
So,
Let's maybe give her a minute and send her a text and then.
I see her rejoining.
Yeah, apologies. I have a really difficult computer. My work computer doesn't allow a lot, so sometimes it does stuff like this. I'm really sorry for this once again. So I presume you saw the Max Verstappen case, and then I was kicked out, right?
Yes.
Perfect. So we can resume. So the Max Verstappen case, the name Max was simply too common to overcome opposition against Air Max. So the key takeaway of these two decisions is that even an athlete, a famous athlete, can be prevented from registering his own name based on prior rights, unless the athlete is very notorious and this results in a conceptual difference to make it stand on his own. Fame can help you overcome an opposition when registering your trademark through the principle of neutralization. So rights, second stage, once registered, can an athlete actually enforce his trademark rights either in opposition proceedings or injunction proceedings? Again, we have two cases. And again, Max Verstappen, who loses his case. So Max Verstappen opposed against the registration of Go to the Max. You see the trademark, the suiting clothing, based on his earlier trademarks, Max and Max Verstappen. And although the Benelux office did accept in this case that Max Verstappen is a well-known athlete, the office decided to dismiss the opposition based on the essential function of a trademark, a trademark must be able to distinguish goods and services. And here the office found that Max and Max Verstappen were not well-known trademarks for the goods and services in question. So once again, Max loses. The second case shows the other side. As you all know, David Beckham is one of the pioneers of successfully transforming a million. And in this case, in Germany, a party was selling perfume testers of David Beckham perfume online. And these testers were marked not for sale. So David, together with other parties, initiated proceedings in Berlin. And the court held that his trademarks rights were not exhausted by these perfume testers, and that he could oppose against these acts. So the fame of a person does not always equal protection as a trademark, but once an athlete's name is linked to goods and services, a trademark is a useful tool to prevent others from coattailing on their success. And then we arrive at the last stage, using your fame as an athlete to invalidate prior rights based on the prohibition of bad faith applications. And here we see another contrast between footballers and Formula One drivers. So in the first two cases on the left, Haaland and Neymar did prevail, and Hamilton did not. So in the first two cases, the claims on bad faith were upheld. And why? Both Neymar and Haaland were able to prove that the trademark applicant should have known these footballers, and there was no other reason to file this application but to free ride on their success. So these trademark applications were invalidated, were not accepted, were not registered. And then in contrast, the third case from Hamilton, Lewis Hamilton tried to invalidate the trademark Hamilton, which was owned by a Swiss watch company. And in this case, no bad faith was accepted because the trademark holder was able to prove that it had genuinely used the trademark for watches for several years, even before Hamilton was born. So furthermore, the Board of Appeal held that the name Hamilton was actually a common name and not exclusively associated with Lewis Hamilton. So key takeaway, bad faith invalidations do work when a third party registers an athlete's name without any plausible commercial logic. And the athlete is famous enough in the territory if the sign is similar or identical to the athlete's name. So let's turn to the second track of protection, personality rights. As you all know, personality rights are quite national rights. And this includes the rights to your name and the right to your portrait or image. But the core principle is actually more or less the same. Athletes can object against the use of their name and image without consent. But as we will see, this is limited. But two powerful examples of where personality rights succeeded are these two cases. So the case of Oliver Kahn and Edgar Davids. And in both cases, the images of the respective footballers were used in a computer game in FIFA and League of Legends. And this without their consent. Both went to court. Oliver Kahn went to Germany and Edgar Davids to the Netherlands. And in both cases, this use was not allowed by the respective courts as it concerned mere commercial use. However, personality rights are not absolute, in particular for public figures like professional athletes, and their personality rights are actually limited in two ways. Firstly, by the freedom of expression. This includes the right to information and reporting, and the perfect example of this, of course, Belgian Red Devils playing tonight against Spain, a court case here in Belgium. And in this case, the Belgian Football Federation invoked portrait rights of the football players on this picture on the left-hand side. But the court dismissed the claim. Why? Because the picture was included in a yearbook, a football yearbook, and the court decided that this yearbook served an informative purpose only, giving the public an overview of football facts of the season and newsworthy items. So the right to portrait is limited by the right to information, and this assessment did not change by the fact that the publisher made profits with this yearbook. So as information could be sold according to the court. And then the second limitation is that professional athletes cannot reach for the sky with respect to the remuneration they can expect from exploiting their portrait rights. And again, a Max Verstappen case where he lost. So in this case, an unauthorized biography was published, which used several photos with his portrait, of course. And the publisher had asked consent and had offered a remuneration of 10% of the net income of the book. However, Max did not agree and went to court to ask damages for this publication without his consent. So the court denied this request actually because it found that the publisher had offered a reasonable compensation. So when only commercial interests are at stake, offering reasonable compensation can tip the balance for the benefit of the publication and to the detriment of the athletes. So in conclusion, what did we learn today? Firstly, Formula One riders are not as successful in protecting their identity as footballers, with Max Verstappen as the ultimate loser. But more importantly, we did learn based on the case law that it's really difficult to enforce personality rights as a public figure due to the freedom of expression, unless your portrait is commercially used. But even if this commercial use exists, offering a fair remuneration can put the athlete out of the game. On the other hand, the right hand, trademarks offer an interesting tool to athletes to protect their identity, but this impact of trademarks is limited because fame as a person does not equal protection as a trademark, and athletes cannot object against prior use by third parties with a legitimate commercial reason. So, game, set, protected, perhaps, but only if the athlete plays the right shots. Thank you. And sorry again for the technical errors.
Thank you very much, Myrtle. No worries. And now with Pauline show.
Good morning, everyone. So I'm going to share my presentation. Is it working? Yes, perfect. So nice to meet you, everyone. I'm going to talk today, like everyone, about sports and IP, and more specifically about the Olympic Games, who took place in Paris in 2024. So the Olympic Games are much more than sporting events. From an IP perspective, they are one of the most heavily protected trademarks in the world. So I like to say that in a word, it's a bit like Voldemort in Harry Potter, he who must not be named, because you can't use at all the name Olympic Games. And I'm going to explain why. So if you use the wrong logo, the wrong hashtag, or even the wrong t-shirt design, you are going to end up in a court for sure. So this presentation is intended to help you understand what is permitted, what is prohibited, and I'm going to give you a few advice for your clients who are in a country hosting Olympic Games. So why the Olympic Games matter for IP? So the last Olympic Games took place in Paris in 2024. They attracted millions of spectators and generated intense commercial interest from companies eager to associate themselves with this event. So this is why it's an important topic for IP law. So I'm going to give you the legal framework. After I'm going to talk about ambush marketing, and I'm going to give a few examples of case law in France. So the legal framework, there are three layers for the Olympic Games. The first one, the most important one, is the Olympic Charter. So it defines what are the Olympic properties. So these are the five ring symbol, the flag, the motto, the anthem, the torch, the mascot, the logo, the slogan, and any reference to a specific edition like Paris 2024. So these are the exclusive property of the International Olympic Committee. The second layer is the national legislation. So each hosting country passes specific legislation to reinforce the protection of the Olympic properties at a national level. So in France, we had an edition of the sports code, which was amended for this event. And this permits to have specific protection for the Olympic Games. The third layer is general IP law and civil liability. So we have our French intellectual property code, which can sanction like free riding, like parasitism. This is a French responsibility. And what is specific is that the French post code is autonomous, so you don't have to demonstrate a likelihood of confusion. You just have to demonstrate that the Olympic properties were used. This was confirmed, fun fact, by an important decision by the French Cour de Cassation, so the Supreme Court, in 2009, and a party was condemned for having used the phrase "the Olympic Games of sex" in a magazine. So, what is forbidden? The first thing which is forbidden, for sure, is the infringement of Olympic properties. So, as I said, there are the Olympic properties, which are the flag, motto, and theme. So you can't use the terms Olympic Games, JO, Olympiad, if you are not authorized to do so. There is a narrow exception for purely informational or critical purposes. However, in France, it is very strictly applied. The second one is trademark infringement. So the Olympic Games have many trademarks covering all classes of goods and services. So using a similar sign, if you use a similar sign, sorry, you are going to be condemned for infringement. And the third one is ambush marketing. So it relies, on civil liability. And it's a complex area because it's when you are going to use a sports event to promote your trademark without spending any money to do so. So now I'm going to give you a few examples in French case law rendered during the Olympic Games in 2024. So the first one was rendered on August 2024, and it was about t-shirts, two t-shirts who were marketed by a company called 11 Paris. It's a French company. And the collection included two t-shirt designs, one for adults with 5 hearts with the colors of the Olympic rings and a slogan, French Love Team 2024. And there was a t-shirt for kids with the same 5 arts, but without any reference to the Olympic Games. And in this case, the court held that the 5 arts in the exact colors of the Olympic rings, combined with the reference of the Olympic Games, constituted an imitation of the Olympic properties. The second case study, I'm going to talk about the importance to analyze your contracts very strictly. So there was a company that had was sponsoring the Olympic Games in Beijing in 2022, and they did a very commercial marketing campaign in France with buses all over Paris. They did a flash mob around the Olympics. They distributed some goods with references to the Olympic Games, and they were also condemned for infringement and parasitism. Sorry. A third case that was rendered during the Olympic Games, it's very interesting because it was about Lyca Mobile, which is a French mobile telecommunication company. And they were not an official sponsor of the Olympic Games. And they only used hashtags like Paris 2024, Olympic Games, and mascots. And what is interesting is that they were condemned because they considered that even if these hashtags were used for informational purposes, they told they had a link to subscribe to their commercial offers at the end of the publications. So the courts held that it was these hashtags were used for commercial purposes. So they were condemned also. So in the end, what is allowed is there are only three legitimated uses that are allowed it. The first one is for editorial information, but as I said, if you have a link on your article to say subscribe for commercial offers, you are going to get out of this exception. The second exception is if you use the terms Olympics in the common language in your private social media. However, if there is a mere commercial use of these terms, you are going to be in a case of infringement or parasitism. And the third exception is for non-Olympic sponsors of athletes. But again, the exception is quite strict because if your company directly sponsors an athlete, but it's not an official sponsor of the game, you can communicate, but you must not reference the Olympic Games. You must not use an Olympic symbol. And this campaign must have started at least 90 days before the Olympic Games. So it's quite hard for trademarks like Adidas, Nike to talk about their partner without any reference of the Olympic Games. So if I can give you a few advices for your clients, I would say first that you have to read your contracts very carefully because that's not because you are a sponsor of one Olympic event that you will be allowed in the future to use the Olympic properties in your marketing. The second one is to check your marketing calendar because if you start to talk about sports during the Olympic Games and your commercial campaigns were never oriented to the sports, you are going to be from start accused to use the Olympic Games for your strategy. The third one is to audit your social media strategy and to communicate in your company. You have to tell everyone that using a hashtag is not okay, that you may be condemned for infringement or for parasitism. The fourth one is not to be clever with any imitation. Using the colors of the 5 rings is a problem in the case law. So you can have imagination, but you really have to take some distance with the Olympic properties not to be condemned. And the fifth one is if you want to be associated with the games, pay for it. Become a sponsor. It's quite expensive for companies, but you will be able to use the Olympic properties as you wish if it respects your license agreement with the Olympic Games. So these games are is the most famous event in the world, but you have to advise your client and tell them that the Olympic properties are really, really protected, and you can't even use these words in your campaigns if you are not an official sponsor. Thank you very much.
Thank you very much, Pauline and Myrtle. It was very, very interesting hearing you. So going to save time, going next to our next speakers. I'm just going to share my screen again. So our next speaker is Emma Varty, and after that, it's going to be Arena Chiara. Emma Varty is an English lawyer who's a senior associate at Can you see my screen?
Not yet. Oh, there we go. Yeah.
So Emma Varty and Arena Chiara are going to talk about sports in the online ecosystem. Emma Varty is an English lawyer and works as a senior associate at Field Fisher intellectual property team in London. She specializes in intellectual property, technology, data disputes, and tackling counterfeiting issues. She's also involved in cases related to intellectual property infringement arising from generative AI and was involved in a number of high court cases. In considering intellectual property in the context of emerging technologies, including claims relating to database rights in sports betting software and copyright user interface. And Arena Chiara is an Italian lawyer with over 6 years of experience in intellectual litigation. Can you see?
Yeah.
Okay. Including arbitration mediation. After working in a number of prominent law firms in Milan, she recently became a sole practitioner, focusing on copyright law, information society service providers, liability, dealing with anti-piracy activities and generative AI, and acts as a legal consultant for the Motion Picture Association, EMEA. She's currently pursuing a PhD program at the University of Pavia, investigating the question of copyright infringement of online works during the training and use of generative AI systems, as well as possible solutions. She's also a member of AIPPI Italy, and past 2 years she has also been a member of our committee, the Young AIPPI members. And she's going to discuss online piracy of sports and live events in the EU. So the floor is yours, Emma. I'm just going to stop sharing.
Great, thank you. Can you see my screen okay? Great.
Yes.
Fabulous. So thank you, Lynn, for that introduction. As Lynn said, I'm a lawyer at Field Fisher based in London, and I'm going to be talking about some of the issues that sports brands and sports personalities have been facing with the increasing use of generative AI. And given my background, I'll be talking a bit about it from the UK perspective, but there's obviously a lot of crossover between English IP law and EU IP law and other jurisdictions. And the challenges I think that the sports individuals and sports brands are facing are definitely global. So what is generative AI? I'm sure you'll all be familiar with generative AI by now, but just to recap, generative AI is a subset of artificial intelligence, which is trained on large data sets of content from which it learns underlying patterns and relationships. These models can then generate new content based on those learned patterns. often in response to user inputs or prompts. And generative AI models become more sophisticated with the more data that they receive and generate. And as the models become more sophisticated, they can create more convincing and human-like outputs. And so different models can generate different types of content. So you've got language models that generate text, and I'm sure you'll all be familiar with ChatGPT and Claude and Copilot and things which are becoming very everyday used in our everyday lives. You've got image models. So I've generated 2 images examples on the screen there. And that's an image model. You can also generate video content, which will produce films, etc., and also audio content, which will produce things like music and speech. And because generative AI creates content based on the learned patterns, it can generate realistic photos and videos of events that have not actually occurred. So the example I've included on the screen is obviously Harry Kane lifting the World Cup, which I very much hope will happen over the next coming weeks, but obviously is an event which hasn't actually occurred yet. And the way that the generative AI model can create these images is that they've learned through the training data what Harry Kane looks like. It's learned what a World Cup looks like. And so it's able to create that image based on the prompt Harry Kane World Cup. So how has generative AI impacted the sports sector? Well, one of the big issues is that generative AI video and image models are being used to create outputs which copy the likeness of well-known sports players, such as the examples on the slide. And these are often referred to as deep fakes. And the examples on the slide were taken from a BBC article, which you can see on the left there on the screen. And the examples include Mbappe, who's a famous French footballer, on a snowboard holiday with his tortoise. And then in the middle, we've got Ronaldo cutting Messi's hair. At the bottom, we've got David Beckham dancing on the pitch in a Three Lions kit. And on the right, we've got Michael Carrick, who's a Manchester United coach, cutting the hair of a famous social media sports personality. And the images on the screen obviously look quite harmless on face value, but deepfakes can be a real problem. And this is because sometimes they're used to generate content which can be offensive, which can damage the player's reputation and then sometimes the team by association. It can also be used to create false product endorsements. And that's also a concern, especially for players who want to monetize their image. And another issue that's happening is that generative AI is being used to create fake sports matches or to manipulate current sports matches, so to make a goal appear that it's happened when it hasn't actually happened. And this again can be damaging for the players, the sports teams, and also drive business away from authentic sports reporting platforms. So deepfakes and these misinformation videos are one issue. Another related issue is that sports brands are having their trademarks and brands appear in some of these image and video outputs. And if we're looking at the examples on the screen, we can see Mbappe is dressed in sports gear. David Beckham's got his Three Lions kit on, and Michael Carrick's wearing a shirt that has various trademarks, what looks like an Adidas trademark and a Manchester United trademark on there. And obviously, these trademarks are being applied in these images to non-authentic goods, and their branding can also be used in other ways in outputs, which make the outputs look like they're genuine content pushed out by these sports brands or in some way associated with these sports brands, which can be damaging. So these are some of the key issues. So can IP rights help? So we've already heard from Myrtle a bit about image rights and some of the difficulties around those. But in the UK, we don't have an image right like some jurisdictions do. Obviously, in other jurisdictions, this might help. And I understand that in response to deepfakes, Denmark introduced a new law in 2025, giving people a copyright-style ownership over their face, voice, and likeness. And the UK government confirmed in a report it did on copyright and AI that it released earlier this year in March that it's seriously considering introducing a personal image right in order to deal with the issue of deepfakes. But at the moment, that's not something that can be relied on in the UK. So another IP right that might be able to help is trademark rights. And again, we heard a bit about that from Myrtle earlier. But under UK law, which is similar to EU law, a person can theoretically register their name, sound clips of their voice, or images of themselves as trademarks. But registration might be difficult because these characteristics will need to function as a badge of origin. And so are only really useful for well-known people. But if successful, then people might be able to use these rights to enforce against deep fakes. And it's not a new phenomenon that well-known people are using trademarks to protect their likeness. But I think since the growing use of generative AI and deep fakes, we've seen a growing number of these sorts of trademark applications. And again, I've put a few examples on the slide. So Luke Littler is a really well-known English darts player, and he's registered a mark to protect his face for a range of goods and services, including downloadable virtual goods in Class 9. You've got Cole Palmer, who's an English footballer, who's on the bottom right there, and he's registered the name Cold Palmer, his face, similar to Luke Little, and also a motion mark of his shivering celebration that he does when he scores. So if you go on the UK IPO and look at that registration, you can see a video of him performing that shiver celebration. You've got Usain Bolt at the top right there, who registered to protect his signature pose, and that's a US registration. And then, not strictly related to sports, but the EU IPO has recently received a sound application in relation to the Italian singer Giussi Ferrari, who applied for the phrase "Sono Giussi Ferrari," which I understand means "I am Giussi Ferrari." Although apologies to any Italians on the call if I've really butchered that pronunciation. But that sound mark has been registered for various goods and services, including goods again in Class 9 relating to tech products and digital content. So we can see from these examples that people are increasingly using trademarks to try and protect their likeness, although it remains to be seen in terms of some of the enforcement issues that Myrtle obviously touched on earlier. So under UK law, we have passing off, which individuals might be able to use. So to prove passing off, they'll need to show goodwill in their image, misrepresentation, and damages. So this could be helpful in circumstances such as false endorsements and false supporting of products. However, given the need to prove goodwill, it's likely only going to help those really well-known individuals. So again, it's going to be quite limited. And then finally, you've got copyright and then related rights in terms of performance rights and moral rights. And then these rights might be able to help, but in terms of these rights, they obviously attach to the work themselves. So they'll attach to the film work, the sound work, rather than the person subject to the work. And so when we're thinking about the scenario of a deep fake where someone's likeness is being reproduced in a fake scenario, the need to show a substantial reproduction of the work I think is likely to be difficult. So I think the application of those rights might be limited when we're thinking about deep fakes. It's also worth noting that sometimes there might be some non-IP related laws that can help individuals subject to deep fakes, such as data protection laws, privacy laws, and potentially defamation. But I'm not going to touch on those today. And then in terms of the second issue that we discussed on the slide earlier, in terms of brands being reproduced in the output. So for example, the brands that were appearing in some of the sports clothing on the images we saw before. Again, similar rights are going to come into play, so potentially trademark rights, passing off, and potentially copyright. And that will depend on the nature of the output. So if you can establish that an IP right has been infringed in one of the outputs, then it might be still difficult to enforce your rights. So firstly, who is going to be responsible for the infringement? Is it going to be the AI developer or the person who's generated the image? And in the Getty Images Stability AI case that was in trial in the UK last summer, which considered the Stability AI's image generative AI model, the court held that rejected Stability AI's attempt to hold the user responsible for the appearance of Getty Images watermarks on image outputs. And that was because Stability AI had control over the images in their training data sets. And it was because of the images in the training data sets which had Getty Images watermarks that you were seeing some Getty Images watermarks in the output. But obviously the responsibility of the infringement is going to depend on the facts of each case. And in reality, a lot of the harmful content that we've been considering today is going to be circulated widely on online platforms, including social media platforms. So takedown requests are likely going to be critical for sports brands and personalities trying to tackle this sort of content. And it may well be that we see platforms introducing more mechanisms to help people take down generative AI content, which it can be considered harmful. So thank you for listening. That's all I had to say today. As Lynn said, I think at the beginning, we're going to be taking questions at the end, but also feel free to connect with me on LinkedIn if you found this discussion interesting. I'm always happy to continue. And I'll now hand over to the next speaker.
Thank you very much, Emma. Do you all see my slides? Fantastic. And thank you also to Lynn for the introduction and to the AIPPI committee for this opportunity. Today I will talk to you in 15 minutes of tackling online piracy of sports and live events in the EU. Indeed, Emma discussed about the threat of deepfake, but there is also another threat that is online piracy that can really endanger the sport ecosystem. And I will briefly address why broadcasting rights for the sport organizations are so important and what kind of damages piracy can cause to them. And then I will give an introduction about the EU Parliament and Commission understanding of the problem since 2021 and even earlier, discussing the copyright in the Digital Single Market Directive. And then which are the instruments that we have in the EU to tackle this problem. And lastly, the next steps that are envisaged by the EU legislation, especially the EU Commission. Indeed, I think this topic is really important now because the EU Commission is indeed discussing and assessing the possibility to introduce a new legal instrument to protect specifically the live sport event and other time-sensitive events. As can you see from these screenshots that I took from public data available online, mostly from materials published by the companies such as or organizations such as the International Olympic Committee or, for example, UEFA or FIFA, you can see that the money that are in discussion in this television broadcasting rights and streaming are really a lot and take the lion's share of the revenues of these companies, both on the side of the organization of the sport events and also on the side of the broadcasting company that brings these events to the end users. Indeed, for example, Pauline talked about the Olympics, but and especially under the trademark point of view. But you can also see that from here, the most part of the revenue of the Olympic Committee is indeed based on the revenues from licensing broadcasting rights that increased a lot in the last 30 years. And as you can see, in 1993 was just $1,000 million. Revenues on that, while now for the 2024 was around $4,000 million. And also, for example, just the negotiations and agreements with broadcasters such as NBC Universal can reach $3 billion partnership. UEFA and FIFA are no less and are not exception. On the contrary, they this trend is even more emphasized because, for example, for the next year, the UEFA hit 5 million revenues for licensing its broadcasting rights and FIFA as well. So there are also already available a lot of studies and surveys regarding the possible damages that online piracy cause to the live sport transmissions and organizations of events. For example, in Italy, we have recently we have seen the release of the study from FAPAV and Ipsos in June 2026 on 2025 data, according to which the estimated damage to live sports due to piracy amount to 400 million euros, while the total loss of tax income for the state due to piracy amount to 400 and 800 million euros. Moving to France, ARCOM study of 2024 on 2023 data said that a loss of revenues for live sport due to piracy amount of 0.3 million euros. And in Germany, the situation is no different. Indeed, the economic losses to the streaming sector, including sports, amount to 2.4 billion euros, and total loss of tax income for the state of 500 million euros. While in Spain, according to La Liga press release of 2025, the estimated damage to the Spanish football clubs is of 600-700 million euros. This issue is not at all a minor. Indeed, the monies that the companies receive for the licensing of broadcasting events will determine how much the companies will be allowed to spend on the organization of the events and on the salary of the sport players and all the other organization around it. So the European Commission and the European Parliament are really aware of these issues. And indeed, already in 2021, the European Parliament released a resolution in May addressing the European Commission to tackle this problem. And in particular, the Parliament requested to specify that for the protection of live sport events, a timely action from internet service provider after a notice or a request sufficiently determined by the sufficiently specified by the right holders should be enough for an immediate action from the intermediaries. And in particular, the Parliament specified that this action should happen no later than 30 minutes. This is why, because the entire, or at least the most relevant part of the revenues connected to live events and the value of it are indeed related to the moment where these events took place. So basically, people are not really interested in the results or in seeing the game that already happened days ago, but they just gonna see the results. So the entire broadcasting value of the game is during the duration and the real-time transmission of these events. And that is why they kind of differentiate between, there is the difference between a normal copyright protected content that can also take a few more to be addressed. An immediate action is therefore needed to guarantee an effective protection of this content. The European Commission replied to this resolution in 2023, issuing a recommendation, so non-binding legislation that basically emphasized the need for the member states to provide effective protection to the live sports organizations. So these organizations that set and organize the entire matches, or for example, for the Olympics, so all the games during the entire duration of them. But the Commission was silent in terms of a specific duration and timing for expected action from intermediaries. The Commission said that the action should be prompt or should be in due time, but there is no specific address regarding the timing. And this indeed, as we later will see, bring to a spotted effectiveness of this resolution, because there were some member states that really followed the Commission opinion, while others really are not doing anything in particular to assess this problem. What is the EU legal landscape that we already have to address online piracy of live events and live sport events? Well, basically, we have two options. The first one is notice and take down or notice and stay down that are addressed in the Copyright Digital Single Market Directive at the Article 17, according to which online content sharing service providers are liable for unauthorized acts of communication to the public of copyright-protected works unless they act expeditiously to disable access to or remove from their websites their work upon receiving a sufficiently substantiated notice from the right holders, and make best efforts to prevent, also for the future, other infringing uploads. And this is the only case we have regarding especially the future, so the need to stay down. And this is because online content sharing service providers have tools that are able to detect the new infringing activities that are essentially the same of the previous one that right holders already communicated to them. We also have Article 16 of the DSA, according to which the hosting service providers shall process any notices that they receive from right holders in a timely and diligent, non-arbitrary and objective way. Lastly, Article 22 of the DSA provides for a priority to the notices sent by the trusted flaggers that are recognized and empowered in every singular member state. Aside from the notice and takedown instrument, we also have the no-fault injunctions for the intermediaries. And in particular, we have Article 8, Paragraph 3 of the InfoSoc Directive, according to which member states shall ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe a copyright and related rights. This means that the intermediaries will never, in this particular case, will never see an assessment on their liability. These are no-fault injunctions, so this means that the authorities of the member state just have to order the disable or removal of the infringing content from their services, but without issuing damages in practice. And then we have also Article 4 to 6 of the DSA, according to which this kind of injunctions can be applied to whatever intermediary is active in the EU. So from the mere conduit providers to the caching providers and hosting service providers. Now the practice, like in practical term, the internet service providers, so network access provider, are the kind of providers that are mostly subject to this kind of dynamic injunction, that are also named as live injunctions, where the provider should act immediately within, most of the times within 30 minutes or around that period of time. But the DSA specified that whatever intermediaries can be subject to do the same, depending on the specific services that he's providing. And lastly, Article 9 of the DSA lists a number of requisites of injunctions, so that the injunctions should have to be compliant with the DSA in order to guarantee a complete set of information to the intermediaries that have to react and act immediately after receiving this order. and also a feedback system from intermediaries to right holders and to authorities. Briefly, I would like to give you a landscape on the live dynamic injunctions presence in the EU. So basically, most of the west part of the EU has this kind of measures. That could be an administrative path or a civil path. So depending on the kind of legal landscape that the member state or the European state, considering also the UK, has. But in those countries, the protection of live sport events are mostly covered. And lastly, one point of the available instruments that we have is indeed regarding the shifting the focus from ISP, so network access provider, to also other intermediaries, and in particular registrars. So basically the kind of intermediary that are responsible for registering a domain name for, in that specific case, a pirate organization or a subject wanted to start pirating. And looking far away from the EU, so in particular in India, already UEFA was able to secure an order according to which not only the internet service providers of India are responsible, and not responsible, sorry, they have to implement the blocking measures. Indeed, also in this case, it's a no-fault procedure for the intermediaries. But also the registrars have to play their part, removing and basically suspending the access to the domain. And this will result in basically a blank page to the users that will access this domain once the register has put in place the measure. Also, the Indian court decided to grant to UEFA also the ROI action, that we call it that way in the EU, but basically it's a right, procedural right for right holders to receive information on the kind of the broader set of information that the provider has on its client that registered the infringing website. But looking back to the EU, we also recently know that in Italy it was granted to Lega Serie A, so the organizing committee and a company for the Lega Serie A events in Italy, and also Serie B, against Namecheap and PDR, which are two registers that had not only to suspend the infringing domains, but also with a dynamic dynamic nature, but also to provide information to the right holders. And to conclude, my final slide addressed the next steps that EU legislation will take in the forthcoming months, probably. So basically in April, June 2025, the Commission launched a call for evidence for the assessment of the recommendation that I previously mentioned on combating online piracy of sports and other live events. And after this call for evidence, where the Commission collected more than 90 feedbacks from the stakeholders, they issued in November 2025 an assessment of the effects, concluding that basically the recommendation was useful in a way to for some member states, for example, as Greece or Italy, that took from there to improve their system and to provide special legislative framework to protect this kind of rights. But also they recognized that this was not basically enough to protect this kind of rights, because most often the notice and takedown are not handled in a timely way by providers, and especially providers that are not online platforms or hosting services that are based abroad. so far from the EU territory. And so the Commission wanted to assess in the next months if there is a space to introduce a new legislative tool to harmonize this protection across the EU. And precisely a year later, so concluding in June 2026, there was a second call for evidence launched by the European Commission to address the effectiveness and potential of improvement of the copyright in the Digital Single Market Directive, so 790 of 2019. And during this call for evidence, the Commission collected more than 500, if I'm mistaken, feedbacks from right holders and also from intermediaries. So a lot of feedback, and is assessing indeed probably within the end of 2026 and maybe beginning of 2027 to introduce a new tool specific for this kind of protection. Thank you very much for the attention, and please forgive me if I will jump now because of medical issues, but I will be more than happy to follow if you have any questions by email or on LinkedIn. Thank you so much.
Thank you so much, Chiara. And Emma, for the interesting topics and approaches, the new approaches you presented on enforcement of rights in the online space. So now I'm just gonna do a real quick introduction to Tia Schulz Zhao. Okay, sorry. And I'm sorry, we're gonna run a bit over time, so please, we would love to if you could stay tuned with us. Tia Schulz Zhao is an Australian counsel at CMS Australia. He's specialized in intellectual property, life sciences, healthcare, and technology, media, and telecommunications. His work focuses on enforcement of cross-border IP infringement, as well as licensing, transfer, and unfair competition. Besides, Tia regularly advises on commercial law aspects and was a senior visiting scholar at Tsinghua University Law School in Beijing, and he worked as a trainee beforehand, a trainee lawyer at the European Patent Office in Munich. And he's going to discuss branding and advertising at sports events. And following Tia's presentation, we have Raphael Zingg. Dr. Raphael Zingg is a Swiss lawyer and a partner at boutique law firm AIPPI, where the practice focuses on technology law and intellectual property. He was previously an assistant professor at Waseda University in Tokyo and worked as a visiting scholar at a number of foreign institutions, including University of California in Berkeley, University of Hong Kong, Singapore Management University, and the Max Planck Institution in Munich. And he's going to discuss patent litigation in sports in focus on UPC cases. And the floor is yours, Tia.
Yes, thank you very much for this kind introduction, and I will share my screen and hopefully everyone can see it. So thanks a lot for joining the session on sponsorship, advertising, and public viewing. Well, I'm very much aware of time, but since the previous speakers, they have really very much comprehensively already elaborated some of the issues we are discussing now in my presentation as well, we can streamline the presentation quite well. So let's dive in what we are actually going to talk about on what do we have on the agenda today. So basically, we'll discuss sponsorship issues as well as public viewing legal aspects, and we will always have a closer look at the litigation considerations. So let's start with the sponsorship stuff. So some of the presenters have discussed before what sports brands are actually or what kind of brands are we actually talking about. When we're discussing sponsorship questions, we are focusing on the copyright side, the trademark side, the registered trademark side, as well as the unregistered trademark side of sports brands. So like in practice, those like are like logos, team badges, colors, brand names, and everything what you can imagine of being like a registered trademark. So these brands are kind of like combined in a way with a sponsor. So basically, if we're discussing about like sponsorships, sports sponsorship in particular, we are like discussing about contracts, where like this freedom of contract applies in the broader sense, and the aim is always like to kind of like create a kind of like closeness between the sponsor and the sports brand, with the absolute aim to have increased visibility for like the sponsor, and like that the sports brand per se also benefits from it. Well, a very common approach how like these kind of like agreements are drafted or like are concluded is are like kind of like team sponsorships. So these are sponsorship agreements, partnership agreements between a sponsor and a sports team. And in that way, the sponsor receives kind of like his brand exposure, but offers kind of like a financial support for the sports team, or offers certain equipment and other resources so that the team plays well and performs well, so that there's like a joint benefit for both parties. But we are not only discussing about like team sponsorship, there's also a certain form of sponsorship for certain sports organizations. And since every one of us is following the World Cup, the football World Cup going on, we will have a closer look at how FIFA actually structures their sponsorship agreements, which is kind of like very interesting. Well, so they have a different layer system, or like a multi-layer system within FIFA. So the highest layer, like the top level sponsorship, is you, or as a sponsor, becoming a so-called FIFA partners. So once you're like a FIFA partners, you're like apparent at every FIFA events. You're like kind of like very much included in the policy making when it comes like to global football development and stuff. Apart from that, there are also like different sponsorship agreements with FIFA and the sponsors when it comes like to certain events. For instance, there are like certain agreements only concerning the World Cup, which is taking place now, and like which also takes place in a couple of years. And the bottom layer, let's say that way, kind of like national sponsorships, or like so-called national supporters, where you kind of get certain rights, certain sponsorship rights, or like the obligations within a specific country, let's say like Germany, Austria, or like every host country where a FIFA event takes place. Well, those agreements could govern like certain rights and obligations. As I mentioned before, freedom of contract applies here in a broader sense. But what's very like key to like those sponsorship agreements are always like getting marketing assets out of these like agreements. How do you do that in a sponsorship form? So, and on the one hand, you have as a sponsor certain visibility in media. For instance, you are like shown in the TV screening during games, or like during like the venues or similar locations. But also there are certain ticketing and also hospitality packages that you may apply for, or like you may offer as a sponsor. And in a lower bottom, like as we discussed like before, like the 3 different layers of sponsorship agreements for like FIFA is kind of like getting integrated in the grassroots initiative and building up your brand from kind of like a lower scale. So these are kind of like the key content, and what happens from the litigation perspective if you pretend to be a sponsor but you're not. So like the most important message here is that if a sponsor, or like if a non-sponsor acts as a sponsor without being a sponsor, that's always subject to national law enforcement. So like we are speaking about national law enforcement in Austria, Germany, like all of the European countries. And of course, there are like different like legal actions or legal grounds may apply for actions to be taken for against false sponsorship claims. In a broader sense, that's a way of misleading advertisement. So in every jurisdiction we have represented here on the speaker panel, I'm definitely sure that there are like certain actions to combat or like to prevent like misleading advertisement in many jurisdictions, in particular when it comes like to Germany and Austria, like, or like in German speaking areas, that's like unfair competition law claims. But definitely, I'm very much aware like that different jurisdictions have different like actions to be taken. In to summarize those actions which are available, that's like on the one hand it can be like ambush marketing, and general false sponsorship claims can also be like a distinctive claim in any of your jurisdictions. So that's it from the first part of my presentation, the sponsorship side. And also, I'm very happy to share some insights regarding the public viewing side of sports event. And I'm very grateful about Chiara's presentation, which has like kind of like shared like the commercial or like the business side of public viewing or broadcasting of sports events. From the legal side, like, so what kind of like rights are we talking about when we're discussing public viewing issues? So firstly, we have to consider copyright and neighboring rights issues, because all of the contents, the graphics, kind of like audiovisual clips, production elements, that's like protected by like copyright or like neighboring rights. But also a big layer here, or like a key consideration here, are like broadcasting rights. So these rights cover like the rights to like retransmit, or like everything what's like related to public communications can be like summarized among like the broadcasting rights. And the organizer of the sports event can license those copyrights, neighboring rights, or like broadcasting rights. And again, we are here speaking about like contracts, license contracts, where again, like the freedom of contracts applies in a broader sense. But just like for you to be aware, like the classics, like we can get like a non-exclusive license or like an exclusive license. And in many aspects, when you are discussing about like major sports events, like media companies purchase an exclusive license for live broadcasting rights, and they can, by getting like those license rights, secure like exclusivity when it comes like to market access. Well, let's have again a closer look at how FIFA structures the public viewing guidelines. As I'm definitely aware, like we are all following those games either at home or in public viewings. But the key message to start with, like, you need to get an authorization by FIFA or like the licensed broadcaster to actually host a public viewing event. So that's the first and the most important message, because public viewings are very much regulated and then highly restricted. On the one hand, it's like restricted on what kind of like broadcasting signals are allowed to be used, because you're only allowed to use like the official ones for sure. And on the other hand, the restriction also covers what kind, or like which kind of like brands, trademarks, and signs and stuff are to be used in combination when you're hosting a public viewing event. And just like that, we are all on the same side. We're only speaking about public viewings in a commercial aspect. And what does it mean, commercial aspects? So most importantly, it's something where you get people pay entry fees, where you have drinks served, for instance, or like where sponsors are apparent. And if we look at Austria, for instance, I know we are a very small country, but that's why we are not that much represented at World Cup. So public viewings is a big thing here. So what's the situation is like in Austria, for instance? So firstly, there is a capacity threshold, like that everything below 100 attendees, you're free to go. So like that's not, so there is the bottom lines. And most importantly is that every like bar or hotels or like any restaurants which offering kind of like a TV, which is running a TV, like in any case, that's not a public viewing, even though we are speaking about like commercial activities. So commercially speaking, public viewings, which are like governed by the FIFA guidelines, that's something where you pay entry fees, serve drinks and food, and get like kind of like have the sponsors be apparent there as well. And in this case, just to repeat myself again, get the license, otherwise you will get troubles with FIFA. And what kind of troubles are we speaking about? So generally speaking, we have the contractual claims and the non-contractual claims. I think that's very much clear. And that's something what we and the audience I guess is very much aware of already. It's not far away from home because that's like what applies to IP infringements in general. I would just have a closer look at that last slide actually here on the potential claimants. So who is actually able to assert claims if you violate like sponsorship agreements, or like you falsely advertise without a sponsorship agreement, or generate like public viewing or host a public viewing event without like an authorization. So firstly, we're talking about like the sports organization fee, for instance, or the sports team, which can assert claims, but also be aware that competitors may also assert claims because it's a breach of law, and they may take actions. And in many jurisdictions, interest associations are very prominent and key players when it comes like to litigation and enforcing those kind of like IP infringements. So mostly consumer protection associations may claim against like misleading advertisement and also false sponsorship claims. So just be aware that there are like different players apart from the sports organizations who may assert those claims. And which claims are we talking about? Like I would say the IP classics, PIs, preliminary injunctions, but also like injunctive relief, removals, damages, publication and judgments, and everything that we are very familiar with in any case. So that's it from my side. I hope I still have left some good time for Raphael, who is having also brilliant presentations prepared for all of you, and thanks for the for the attention. So Raphael, if you're speaking already, I guess you're on mute. Okay.
Yeah, trying to unmute myself. Thank you so much, for this very colorful presentation. I'm not sure if you see my screen. Has it been working? Yeah, it should be. So we have a switch in topic after all these colorful points on public screening and sports sponsorship and activities, litigation. What are some of the procedural rules that apply in Europe? What are the standards that have been developed in preliminary injunctions? So when time is of the essence, you need to act quickly. There is a competition. We talk about the World Cup or similar, or trade fairs. And now a client comes to you with an issue in the field of sports, but also in any other technology or industry. We can see, at the example of 3 cases, what have the courts decided on the main requirements to obtain a preliminary relief. The first case I want to discuss is the most current in terms of technology. It's a connected ball implemented in Kinexon connected ball that is depicted at the bottom. It's a German startup, raised about 100 million a few years ago. And we're facing a lawsuit by Balino, which is a Dutch non-practicing entity. The Balino lost the case or did not obtain preliminary relief due to lack of urgency, couldn't prove infringement neither. And later on, their asserted claims were deemed null or revoked by the Central Division in Paris. If you look at the football ball that you've been seeing on your screens, if you look at it, this is actually technology by Adidas that is using as well this Kinexon technology. So I'm not sure if it's the same patent that it's implemented in this ball or development of it, but we're still talking about the same firm. Stromer and Revolt is the first preliminary or ex parte injunction that occurred in June 2023, so just after the court started 3 years ago, in which the local division in Düsseldorf issued an ex parte injunction. It was over the dropout construction of the bike, so where you drop out the rear wheel, the back construction here, where you can remove the motor hub and such. And the second interesting part of this dispute is there was actually some guidance from the courts on how to implement injunction, what is expected from the infringers, and how fast do they need to act when having an injunction being served to them. Last, Orthovox versus Mammut, another Swiss first, Mammut, who's doing a lot of great outdoor clothing, but also an avalanche rescue device that mountaineers and skiers can take on their journey in their backpack to make sure that they get saved and can be localized via GPS, typically in case of emergency, where the local division in Düsseldorf issued an ex parte injunction, and that was confirmed then on review and on appeal. The idea of this presentation, and just to look at the 5 or 6 main requirements that you will need to prove in litigation in such a application, and see what is the legal norm. For example, you need to prove there's a sufficient degree of certainty that the patent is valid and infringed. That would be the same for most IP rights. Or similarly, there's been case law, not in the field of sports, but that showed that there was some dispute about what does that exactly mean. The likelihood the patent must be valid more likely than not. Some of the words that have been discussed, but maybe in more relatable terms, the guidance that these disputes gave here, both in Stromer and Orthovox, is to say, well, very simply, if the patent has been maintained in opposition proceedings, that's great. If there has been a nullity action as well in front of a national court, but even if not, and that will be the case in most situations where patents are being litigated, when they're not, subject to kind of cross-country, multiple jurisdictional campaigns, you'll have a patent that's being granted, nothing happens, and then 5 or 10 years later, there'll be a dispute. And there the court said, a long use in the market without challenge could be a positive thing, or as well, if the infringer failed to present the relevant evidence or prior art. In ex parte, of course, disputes that will be different, because the infringer would not have had the time yet to demonstrate or present, prior art documents. In the Stromer dispute, however, that was the case that there was a protective letter filed in Düsseldorf, and therefore the court had a look at this protective letter, and protective letters can be a double-edged sword. If you say there's no infringement, that's great for you, but if you don't present arguments on novelty and inventive steps, then you implicitly admit that maybe these are not as problematic. So that was the case here. The Revolt, the defendant, didn't present evidence or supporting arguments about the validity of the right, and therefore that was deemed to be sufficient for the threshold. The main driver also of injunctions, right, or preliminary relief, is urgency. The idea is you need to act quickly, and that depends very much on which countries you're talking about. How quickly Switzerland, we're taking it very slow. So 14 months is still quick enough. In Germany, it's the opposite. Injunction relief has to be filed, within weeks or months. And the UPC, since it is, derived mostly on national case law and courts with judges with their experience as well, in the German at least, divisions have followed kind of this idea that 1 month, or in Düsseldorf 2 months, in Munich is the maximal delay that you can have before the urgency will not be deemed given. Versus Dutch courts have been looking more at has less strictly looked at these numbers. In the case of Stromer, this application was filed during a trade fair, so evidence was secured on day 1, lawsuit filed on day 2, and day 3, then there was a service. So there was very little, to argue that urgency was not given. These bikes in questions were also not available on the market. And ideally, if you have a fair, that's a very good thing. Courts like it also because they have a more difficult time to say it's not urgent, because you say the fair is ongoing only for 5 more days or 3 more days. We need to have a decision today. Orthovox versus Mammut had an interesting question in times of global sales, right? So the prototype of this avalanche rescue device, these transmitters, had been shown in the United States. And then, let's say 6 months later, we're showed at a fair in Germany. And the defendant tried to use this as argument and say, well, there was no urgency. You had a look at the prototype already 6 months ago. The court decided, no, the clock does not start, because you do not know whether the same product will be sold, in Germany, for instance, or very That is, maybe as practitioner, we are definitely using, all of us, I think, information gathered worldwide to prepare. So if you know there's a fair coming in Germany, but you have evidence secured in China or in the United States, you will be preparing your lawsuit and just insert an image, kind of an evidence of that last missing piece that you need in Germany to establish the local link, and that there's something to collect, right? And then Kinoxen is the one that was refused for lack of urgency, and you'll see why. Here we have a timeline starting in September, then cease and desist being sent. The month thereafter, licensing negotiation failed. And then it became very attracting to the NP when in December, UEFA announced that this ball was going to be used in the European Championship 2 years ago. So then suddenly commercial interests rise, there is money to be made. You in theory, could prohibit FIFA or UEFA in this question to use the ball they wanted to at their competition. So in the hold-up situation, they will need to pay licensing fees. Application therefore filed in April. I believe the UEFA Cup or Europe Cup was in June, so very little time to solve this issue. However, this timeline was deemed to be too slow. There was too much delay. You would have to file it before, and you can have an action on the merits if you need over 6 months to kind of decide whether or not you need relief. Another point that's being examined and is softer, let's say, in the argumentation, although legally it's important as well, is the balance of interest. What is the harm for either the infringer or the right holder when there is, a granting or refusal of the injunction? In the Orthovox case, there was some indication that some of it seems very reasonable. Say, well, the stronger the court believes that the patent is valid and the patent is infringed, well, the more likely it is and more justified it is that there is an injunction that's being issued, even though there is a harm, lack of sales and so forth for the infringer. So that will be put in a balance. Some soft factor here were listed in that there was a lot of attention on the allegedly infringing device, had received an award at a trade fair. So that's not just something that's published, on a website and no one takes attention, but really something that the dealers in this market are seeing as being a new product offered by Mammut, and therefore there is even more of a harm for the right holder in case people misassociate that technology. What was contended but not considered was the survival chance of avalanche victims. So that's something you see in life science too. Patients need access to medicine. Here for avalanche, mountaineers, you say, well, they need to have this device because otherwise they will not be saved in case of emergencies. And the court deemed that to be theoretical at best because there were other devices, including the device of Orthovox, right? These ex parte measures, though, without hearing the other sides, have been issued in 2 out of our 3 cases. That's obviously a not representative data set, but just shows that you can obtain in sports and in other disciplines, also in other technologies, you can obtain in the UPC ex parte measures. The court is quite willing to apply rather, strict standards there. What do you need to show? A risk of the evidence being destroyed. That's something lawyers like to argue. They say, oh, but if we don't do it immediately, the plant will be relocalized, everything hidden. In practice, I'm not sure if that's true, but alternatively, what you need to show that there's an irreparable harm, right? And if you have a fair, these 2 cases concern trade fairs. That's very rather easy to show. You say there is products that are being offered. They are substitutable, directly competing products. And this fair is, a summit of sales. So Eurobike was the bikes fair in question for Stromer, where all the dealers are there for the year, decide which brands they're going to service and which bike they're going to offer to their customers. A lot of sports industries characterizing that there's dealers, right? So as soon as you have the dealer, then you have the 10, 100,000 of shops from the dealers that serve the customers. Most brands don't sell that much to consumers directly, right? And therefore, there was an irreparable harm. For Orthovox, an argument too was to say these products were not purchased that regularly. Once you had one of these transceivers, you could keep it for 10 years in your backpack, and they were not replaced that frequently. Therefore, the harm was considered given. In counterpart, as a compensation, what's the right holder will have to do that's a default rule for ex parte injunction, but also in general for standard provisional measures, will have to pay a security deposit, like bank guarantee or in cash. Here in these two cases with Stromer and Orthovox, it was set at the amount of the litigious value, right? So say, well, there is no indication yet in ex parte measures, there is no reply by the other side on how high the damage should be. So the damage for the infringer is certainly not as the same than the litigious value for the right holder, but that's the best kind of guidance that one has, and therefore the amount was set, for example, in both cases at 500,000, and that was also confirmed that this modality was in order. What can you order? You can order injunctions, seizures, interim cost award. In both of these cases, there were actually both injunctions, for the future, and handover and confiscation of infringing products. Since these were fairs, or Stromer at least was a fair, a bailiff came and confiscated, a dozen of bikes, all of the products that are being shown. So you can imagine you have a booth, there's a bailiff that comes and you get a lawsuit served, and you have to hand over all of your products. So the consequences are quite dire, right, for the time of the dispute, at least. Last, I want to talk about what happens in case of non-compliance. Penalty payments will have to be paid. So this Stromer dispute had an instance also, or had a decision on that point, where the court was rather, I'd say, strict, and stated that keeping a booth open after service, I mean, you have a few minutes, of course, but several hours afterwards, that was deemed to be a violation of the order, and therefore some fines had to be paid. The fine is proportional to the gravity of the offense, so it wasn't a lot of money. We're talking about here maybe 1,000 or 2,000 euros for keeping the booth open after the service. There was social media needs to be deleted immediately. Immediately is immediately. A deletion after the next, the day after the service was deemed too late. So 24 hours is too much. And that's maybe, in order for larger firms, but small one need to already, understand what is an injunction and what do they actually need to do, and therefore needs to have a fairly good legal setup and counsel in case of emergencies. And then there was a more blatant violation, let's say, with a few months after the injunction has been passed, having a test bike that was sold at an event, and there the fine was larger, like 25 or 20,000, 20 or 20,000, 20 to 25,000 euros. Yeah, that's all for me. These are some of the guidances that the courts gave in these more technology cases, and I think now hopefully we have a few minutes for questions.
I have a question for you. Do you see that the weighting of injunctive reliefs are different in sports field than other fields?
No, I don't think so. I think sports has the particularities of having, high profile events. So of course, if you're talking about UEFA, that's maybe, known to the judge. And the dealer structure might be slightly differently, but of course, these are standards that can be applied across all technologies. I think it does help sometimes when the judge understands the technology they're dealing with and have a personal relationship with it. But I do not think that per se there are different standards. There is a lot of discussion, right? Is patent law technology specific? But there it's probably more about, software versus biotech, and rather than industry like sports. Yeah. Maybe I had a question for Chiao. So, you talked a little bit about how the FIFA is setting up these contracts, but I was wondering if you know how it flows up. So, how are the players transferring their rights all the way up to, video game publishers like EA Sports or all the personality rights and image rights? How do they go to the club, and then the club does these agreements? or I cannot imagine that large organizations have agreements with single players unless it's, for being on the cover of like, a big game or something. Or
Yeah, thanks for this question. I mean, like when it comes like to football, so as far as I'm aware of, like that many players kind of like bundle their like image rights and sell it out as a bundle. So it's very similar to what you have like with like the music industry, for instance, like that once you get I don't know, like Taylor Swift in your portfolio, you also kind of get like other like artists who are like part of like the same management group, and like and with these like packages you can like kind of like purchase, put it that way. It makes it kind of like easier to get the package you want. But as far as I know from like other like artists, for instance, and that's very similar to what you have like in the sports industry, is that the performance actually of a certain person, let's put it that way, a celebrity, that's always kind of like a moral rights issue. And I understand that's like equally applicable like to sports persons as well. Like once you get like the image, which is that's the commercial side, but once you get like into like the performance of something, that's a moral rights question, and that's highly actually quite interesting to see like where like can an artist or like the sports celebrity or like the athlete say no, that's enough. So for instance, like if for instance like we were talking about the FIFA, like the computer game, I assume, like once like the person like does something stupid like on in the computer game, like what's are like the legal grounds the specific athlete can say, okay, now sorry, that's enough, you got the package, but like sorry, that's goes beyond like my impression, right? And there has been like I know it's get like super nerdy, but like maybe you know like the celebration of like David Alaba like in this Champions League game, where he took like one of the chairs and like celebrated like a crazy guy, and like FIFA like implemented like that like way of celebration. But like from a legal perspective, I think that's super interesting, even though like I totally understand like that iconic picture you have, right? But that's definitely like not part of like the usual package. But now we're discussing about like moral rights. So like to conclude, like it's always like kind of like the balance you have, like the one hand the commercial side of IP, but also consider like the moral rights when we're talking about like all of like these packages.
For example, in the Unibet case I was referring to, like it was both the clubs and the players that were included in the proceedings, and in that case the clubs were arguing that they could execute the personality rights of the players, and it was not accepted in that case. And we also had at Litigation we had a case against a Belgian football player who plays in the Bundesliga, and there the player argued that his football club, was executing his portrait rights. So in my understanding, it's often the clubs that are the one to contract with.
Any other question from the audience? Okay. Since we only got 6 more minutes for our virtual room, so I think it's safe time to close our discussion. I just have a few commercial announcements. I think Nicholas already addressed some of them. Just gonna share my screen again. Sorry. So we have the Young Member Forum at the World Congress happening in Hamburg. Please approach us and meet us. We'd love to see you there. And other national groups having their own meetings coming up. So if it's relevant to you, the second AIPPI Young Members Triathlon of France Germany and Italy is gonna take place on the 20th of November in Milano. It's also gonna be some part hybrid. And thank you very much for listening. And thanks for Emma, Pauline, Myrtle, Tia, Raphael, and Chiara, who had to drop out. It was very interesting. And who knew that sports is really such a wide field that many topics is included in it. Thank you so much.
Thanks for the organization.
Bye.
Much appreciated.
Thank you.
Bye bye.